number 92, Rivera versus the State of New York. Good afternoon, Counsel.
Good afternoon. May it please the Court. Good afternoon, everyone. My name is Stacey Van Malden. I represent Mr. Jose Rivera, and may I respectfully request 4 minutes for four, please.
You may.
I am here today to respectfully request that you reverse the decision of the Fourth Department that affirmed the decision of the Court of Claims, which granted summary judgment to the defendant upon the affirmative defense.
Counsel, was the correction officer, under the circumstances presented here, was he authorized to use any physical force under those circumstances?
The circumstances, the facts are that Mr. Rivera, Officer Waby asked Mr. Rivera, who wears a protective helmet, what kind of stickers he'd like for that helmet. And Jose said, "Please don't do that in front of the other inmates." And then he proceeded onto the chow line. Officer Waby called him back and he ignored him. So this was a violation of discipline. When ultimately he did go back is when the force began, so to speak.
There's also evidence in the record that Mr. Rivera was impolite. Is that right?
Apparently he dropped an F-bomb and said, "Go F yourself," which can make somebody emotional. And even though
this isn't what the claimant was alleging in the lawsuit, and it's not what the IG found, it's not what the state was claiming. So it's a little confusing to me as to whether there really are, whether those allegations on the part of the officer are relevant to this at all, whether there really is any disputed issue of fact as to what happened, which is not what you're suggesting now, in this particular lawsuit in the Court of Claims.
Well, that's what happens when you grant summary judgment. There's only, the facts cannot be brought out entirely. It was, Jose
Well, no. In opposition to the summary judgment motion, you attempt to present the conflicting facts. But so yes, you do have an opportunity to bring them all out.
Well, the facts have always been that he was impolite, so to speak, and that was what brought on the initial aggression from Officer Waby. Now the state is saying that it was unprovoked. There is a provocation there. And regardless of what Waby did, there were 2 other officers there who were acting within the scope and were not mentioned. They are in the initial claim. The initial claim names Officer Waby, Sergeant Latour.
But there's no allegation that they exerted any violence, any force.
No, they did. Well, there's acting in concert, and so many of my clients who have been found guilty of acting in concert did not wield the gun, did not wield the knife, but they stood around. That's what we have.
Counsel, I thought a part of your argument was that there's not a dispute, that at a minimum what these 2 other officers did was come to Waby's, how is it pronounced, I'm sorry, Waby's? Waby's assistance and restrained your client.
That's right.
Which restraint of an inmate seems to be within the scope of employment.
I agree with you completely, and that has been the argument, that when Sergeant Latour and FEMA are responding to they are not next to Waby when this starts. They respond from different parts of the mess hall. And what they're seeing is an officer that perhaps needs assistance. Now, whether they were telling the truth or lying, I mean, they were both, Latour and FEMA ultimately were dismissed, one for lying about the incident, one for lying and participating. Strangely enough, Waby was permitted to retire. Although he was indicted for assault 2 and 3, there's a hung jury. Ultimately, he pleads guilty to official misconduct, that during the course of his employment, he acted in an unauthorized
Okay, but
manner.
getting back to these other two officers for one moment, you say they came in later. I said it seems to be undisputed, because even the state has it in their brief, that they participated in, at a minimum, the restraint, right, of the claimant.
Correct.
Okay.
So they are acting within the scope of their authority because,
Well, and there was a
Well,
term-
there's at least a fact question as to what they thought was going on, correct?
correct. And the Court of Claims did not take into consideration any of the actions of the other officers and focused solely on,
Is that because the court rejected the negligent supervision claim, said it wasn't carried over from the original claimant?
well, this was even just, we
Let's
have,
just stick with my question.
No, the question is,
Is
we
that-
only-
Is that why the court didn't, because it rejected the negligent supervision claim? So he didn't take into account the sergeant and the other officer?
I don't know what the court was thinking, most respectfully. I can't answer that question because ultimately the only.
Let me ask this then. Was the negligent supervision claim brought in the claim that's part of the underlying action here?
No, there's just
Was it
an
brought in the
assault.
original complaint?
No, the original claim was the assault claim.
So there was never a negligent supervision claim brought in any form?
No, there was a claim brought, it was extraordinarily late, it was filed without leave of court, and it was ultimately stipulated out of the case.
see.
Prejudice, it was dismissed.
I
Yes,
see.
it was.
Thank you.
Yes, but your argument now is not about supervision.
Not at all, not at all. There are 3 officers, corrections officers,
so
who are engaged.
I want to focus, if we can, for a moment, on the various factors that are set forth in Riviello. And if we are trying to figure out whether the officer's conduct here is within or without the scope of his employment, do we look at those factors with equal weight? And if so, did the Court of Claims do that, or did it sort of just decide this based on one factor, i.e. the 4th factor?
All the
What I'm trying to get you to do is discuss how the 5 factors apply to the facts here.
The factors, we'll start with it's very difficult for me to read and see at the same time. The connection between time, place, and occasion. They're in the mess hall, they are supervising employees, they are supervising the inmates and making sure they take the correct number of plates and forks. So this is definitely a factor that weighs in favor of being within the scope. History and relationship between the employer-employee, force and excessive force happens because of the nature of the job. This court has recognized
But
that.
that sounds to me like the aid and agency theory or whatever. And I don't know that we've ever adopted that any use of force because of the situation is within the scope of employment because some use of force is permitted. For example, let's take an extreme one. A sex offense, okay? You put somebody in a position where they might be able to do that, and does that mean that the state has waived its sovereign immunity with respect to that it's within the scope of employment? Maybe that's a little too extreme, but just to back that up a little bit, I think we have said that it is one thing to exceed, where there's force permitted, to exceed the level of force permitted, and there's another to completely depart from the standard of conduct and from anything that's permissible.
I don't disagree, but when you're talking about, when you take a prisoner into a separate place and you beat him, that's a frolic of your own, so to speak. But when you are essentially showing all these other inmates that if you talk back to me and you don't listen, you're going to be immediately disciplined. Did he go too far? Sure, of course. But was it because of the passions aroused by the situation that he had been placed in and the discretion given to him by the Department of Corrections? Also sure.
Yeah, well, when this started, it was visible to inmates.
Absolutely. All of it was visible to inmates. What I found out many years after the fact was
Well, I thought they were behind a door.
they were not behind, they were in
I'm
full
sorry,
view.
the door was closed and they were in some other section, yeah.
No, they were in view of all the inmates who were able to give witness statements to the Inspector General.
Thank you, counsel.
Thank you, Your
Counsel?
Honor.
May it please the court, Patrick Woods on behalf of the state of New York. I feel like I'm about to get a question.
Well, I want to start where I
Several.
ended with her, which is if you could walk through the 5 factors and whether or not you think the factor 4 is a determinative factor.
I think it can be a determining factor. I don't think that they need to all be individually weighed the same. I think it depends on the facts of the case. And I think that's particularly true because some of the factors can bleed into each other in terms of what facts matter. And here, a number of the factors, it's not just one factor here that matters. There's nothing in this record that shows that the state should have known that this officer was likely to do something like this, that it was foreseeable to the state. There's no authorization for...
Foreseeability is factor 5. I'm just trying to
Right.
sort of think about how they end up balancing out.
I think certainly we're one of the factors where somebody's acting completely outside of where it's where it's unforeseeable, where there's no history of it happening, where there's no authorization for this kind of conduct, and where there's no benefit to the employer from the conduct, that those factors can outweigh and should outweigh another factor as in time and place, for example, it being while they're on duty.
So why isn't there a material triable issue of fact as to what, not Waby, is it Waby or Wibby? I'm sorry. Do you know the
I have been
pronunciation?
pronouncing it Weeby.
Wibby, okay. One of the above. But that's
Officer
the officer I
W.
want to talk about. The other 2 officers, Sergeant Latour and Officer Femi, I believe is how that name is pronounced. In any event, why isn't there a material triable issue of fact as to whether or not they were acting within the scope of employment, since they're not the ones who initiate the beatdown, that's Officer Weeby, however it's pronounced, and they come later and they are restraining him, which allows, of course, for this beating, but they may very well believe that they are coming to the aid of a correction officer who's at risk and danger, been provoked.
Well, I'll say 3 things about that. First, to the extent that there's liability supposedly being ascribed on the basis of the other officers, that wasn't really in front of the Court of Claims. Part of the reason that
I'm sorry?
that wasn't really in front of the Court of Claims at summary judgment.
Well, it's your motion for summary judgment. You're the one who's got to show that no one is acting within the scope of employment.
That's correct, Judge. And in our motion, we argued that only Weeby was responsible for the actions, and there wasn't even a reply filed to our motion.
Yes, but the position from the claimant has always been the 3 have been involved. I mean, there's no way around that.
Not that the 3 were responsible for the assault or any of the injuries from the assault.
Well, no. He has taken the position that Weeby is the one who beat him, but he has never said anything other than these other 2 restrained him. And I believe at Weeby's criminal trial, he testified that Latour could have and should have stopped it and didn't. And that's the same thing that the IG found.
That's correct,
In
Judge.
fact, the IG's reports only mention that Weeby used excessive force. Doesn't even refer to the other 2 in that way.
That's correct, Judge. And if there had been a failure to protect claim here, a failure to intervene claim here, a failure to train and supervise claim here, I would not be standing here in front of you.
That's not the claims they're going on. As I understand his claim, is that he's assaulted, the state is vicariously liable for the actions within the scope of employment of the officers that are the proximate cause of these injuries. Weeby's the one who's actually beating him. Maybe or maybe not, that's within the scope of employment. But I'm asking about the other 2, because I find that your motion is deficient with respect to those 2, and that's what I'm having a problem with.
Well,
I mean, it's your motion, it's your burden.
I'll say 2 things in respect to that. The first is I don't think the record shows that the other 2 officers were not within sight of the beginning of this altercation. And I don't think that it's clearly, I don't think that you can say that it's within the scope of an officer's duty or their employment to assist another officer in an unjustified assault on an inmate.
But that's what I'm saying. Are there not questions of fact, material tribal questions of fact, as to what they understood
I don't think there are where there
was
isn't.
the development of these events?
I don't think there are. I don't think there are with respect to our burden when we argued and moved and said only this officer is responsible for the conduct, and there was nothing that came
But
back
that's your
saying there's evidence in the
assertion.
record
And
to the
she's got
contrary.
other things that they've asserted.
At page
But
310
did
of
they
the
assert
record,
them in opposition to the motion, I think, is...
They didn't file an opposition to our
Well, if you don't
cross-motion.
carry your burden, they don't have to say anything.
They don't, Judge, but I think we did meet our burden of pleading here.
at page
And
310,
if I could,
at page
sorry.
310, I'll let you go ahead in a second. At page 310 of the record, there's what appears to be an internal determination in the report that officers Femia and Latour are not culpable, which at least to me suggests factual support for the idea that they were acting, that there was an internal determination they were acting within the scope of their employment.
I'm good. Trying to pull that up, but, because I don't think we've been argued that we've been
arrest,
stopped, so
indictment,
to speak.
grand jury heading at the very, it's the last line there.
I'm sorry, can you, sorry.
Sure, there's a heading on page 310, part of the way down the page, arrest, indictment, grand jury.
Okay.
There's a last sentence there.
I mean, as I understand that, to mean it's that they're not responsible for the injuries that were inflicted for the assault here. And if you look at the write-ups of them, there's not an neither one is found to have used excessive force themselves.
Which suggests they were acting in the scope of their employment and what they did? They're not culpable?
I would not agree with that, Judge.
Okay.
Let me ask you this on a little bit larger question, the underlying public policy question and the meaning of our determination here. I've always found these scope of employment cases to be difficult. But it seems the logic of a case like this, where it says that when an inmate fights back and then law enforcement officers use excessive force, and the inmate then sues for the use of that excessive force, that person, that they're offered a defense and indemnification, and they're protected from any financial liability that may result. But if an inmate doesn't fight back, takes a beating, and then attempts to say that it was excessive force to beat me in response to me using inappropriate language, then that person doesn't have the right to sue. So in other words, if you're getting beaten and they beat you too hard, you can sue. But if you're not getting beaten and they beat you too hard, there's nothing you can do about it. You understand the conundrum that this kind of creates.
I understand that is certainly the position that appellant has taken, but it's
Well,
respectfully,
tell
Judge,
me
it's
what's
not- it's not
factually,
correct.
no, slow down. Granted, it's their position here, and I've seen it in other cases too. Tell me why that isn't a correct recitation of the position. I understand your point of view. I'm not saying that you don't have an argument to make. That's not what I'm saying at all. What the state is saying is that we're only liable, this is the state now. The state isn't liable for everything this person does. It's a reasonable point of view to take. My question to you is that factually correct? Is that the state of the law here?
No, Judge, it
Okay,
is
tell
not
me
the
why
state of
not.
the law here. And because as I'm understanding your question, I think you conflated two separate parts.
All right,
It's
well, let me
whether
give it
there's
to you
a-
again, so you do understand my question. My question is if an inmate resists something by a police officer and does something physical to a police officer, if the response to the officer, the correction officer, is excessive force, that inmate can sue because the officer was responding in the course of his scope of his employment. If the inmate does not do anything physical, says something stupid, and then excessive force is used against him, that inmate cannot sue.
And that's where I disagree with you, Judge. It
Okay,
is
tell
not the
me.
case that inmate cannot sue.
Tell me
That
why
inmate can
not.
absolutely sue. It's just that inmate may not, in the court of claims, be able to make out a respondeat superior basis on the assault.
Can they sue the state directly for other liability in addition to suing the officers themselves?
They could, Judge. In addition to suing the officer themselves, they could sue on a failure to train and supervise claim. They could sue on a failure to protect claim.
Which
They
would
could
be
sue
a
on
theory
failure to
that would
intervene claim.
accommodate your failure to control the use of excessive force in the situation where there was no initiating activity.
Correct. Those are areas where it's the state's independent duty to ensure the safety of an inmate, for example, and it is not the case that.
So in those actions, they wouldn't be brought in Court of Claims then? They'd be brought in State Supreme Court?
The individual actions against the officer would be brought in either state Supreme Court or in federal court. The failure to protect, failure to train and supervise type claims would be brought in the Court of Claims against the state.
Thank you.
So of course, if we have court consolidation or simplification, we won't have these problems.
Well,
Yeah, but that's a different,
Just
different
clarify
debate
that
for a
last
different day.
one. They could proceed on the failure to supervise and train in federal court, though, under 1983.
not directly against the state of New York. They could.
But
and
against the officers
against the officer, they could not, I mean, they couldn't make out a Monell claim because it's the
Right.
state and not a
and the
municipality.
municipality, right?
But they certainly can proceed under an Eighth Amendment violation, and because the officer's outside the scope of their employment, they can proceed on a simple assault, under common law assault.
Thank you, counsel. Counsel?
I just wanted to pick up a little bit on that. There are other causes of action, but does the inmate actually get anything? Because if they file suit in federal court saying the officer acted beyond the scope, or in Supreme Court saying the officer acted beyond the scope, the state's not going to defend nor indemnify, and you get an empty judgment. So there's no reason why anyone...
Couldn't you sue the state for failure to supervise in the Court of Claims?
You could.
And
But-
then wouldn't they have to pay if they're found liable?
If they're found liable, it's a lot easier, though, to get, it's harder to, as you go jumping up, we have to
Because it
demonstrate.
seems like you're shoehorning your last claim, which is a respondeat superior claim, which we have to consider sovereign immunity issues and the extent to which the state has agreed to be liable here, which is under the same theory any employer would be liable, and no more. So we have to apply those factors, and I don't think from this argument that you're asking us to overrule Riviello, at least as applied here, right?
Certainly not, but is a corrections officer that is beating an inmate different than a school paraprofessional who uses corporal punishment? That's absolutely against all the rules, but yet within the scope of employment. Is it
Well, what about the DHL worker who gets into a road rage situation, takes out his, I don't know, baseball bat and goes and smashes the window of the car in front of him, beats the other passenger?
that DHL,
Just take it out of the government
Right,
context.
taking it out, I don't know that that's within the scope of his employment. It's much like the bicycle messenger provoking an attack. But what about the city employee who's doing asphalt and hits the motorist over the head with a shovel? That's within the scope of employment. There are any number of cases that are within the scope of employment that were more egregious than what Officer Waby did, and certainly less than what the other two
All right,
officers
so I just want to be
have
clear.
done.
You're not asking us to make a new rule. You're not asking us to change the rule. It's just a matter of clarifying how the court applied those factors in Riviello.
Exactly, and also perhaps noticing a difference between cases decided under Public Officers Law 17, which is about defense and indemnification, versus cases that are respondeat superior. Because when you're working in an insurance area as opposed to a tort area, it can be slightly different in your interpretation. When you look at all of this court's prior statements and holdings, there's always, no matter how the Riviello standard, no matter how far off, if you're within the scope, even if it's because of emotion, it's still within the scope.
I just want to make sure I got your last point. It's that the state can choose to indemnify or not indemnify to whatever degree it wants or doesn't want, but that doesn't have to be coterminous with respondeat superior liability under the common law. Is that right?
That's exactly my argument. And while I still have time, The test is whether the act was done while the servant was doing his master's work, no matter how irregularly or with what disregard of instruction. Waby may have lost his temper because of the passions aroused by circumstance and occasion, but that does not change the fact that he was acting within the scope of his responsibility on January 15, 2010. Thus, I would most respectfully request that the decisions of the courts below be reversed and that this case be remanded to the Court of Claims for trial.
Before your red light goes on, do you want to address the question of the motion to amend, or you want to stay on
Well,
your
the
brief?
motion to amend, this is not a case where all of a sudden down the road, the plaintiff creates, gives information that allows the defendant to amend. This is a situation where they knew all this information before we even filed the claim. Back in 2010, they
And
knew.
so did you, so what's the surprise here?
The surprise
This has
to-
all been played out in various forums.
Because when you plead, the officer is found not guilty of assault, so we don't know how heinous the beating was. And then the other two, and also he's permitted to retire, and he pleads guilty to official misconduct, which is within the scope of his, during the course of his employment, he
Well, how
did an unauthorized
How
act.
did it impact your ability, though, to prosecute this case?
For 4.5 years, the state is denying that excessive force was used or that it was not justified. 4.5 years, you're going into, the notification is about to be filed, discovery is closed. This is the case that the state has been presenting. Now, all of a sudden,
Did you ask for an opportunity to conduct further discovery? I think there was about maybe a year and a half or so, my understanding was, between the time that this, that it was amended and the time that the note of issue was filed.
The note of issue was filed in August of 2015. The motion was made in June 2015. The note of issue had to be filed by August 31st of 2015. Decision was not made until 2016, and the additional discovery, which was supposed to be provided to the court within 45 days, was not provided for over a year to us. So we didn't know at that point whether we were going to have the information or not have the information. Had we had it within 45 days, I could have moved to strike the note of issue and done some other investigation. But based on...
Did you ever indicate what more you would have done or asked for permission to go beyond because of all those circumstances you've just described?
Actually, the bottom line is that what I was given by the Inspector General, I probably didn't need more. The big prejudice here is you get an unfair advantage. Can the state do this all the time? They know that there's a beyond the scope issue when they answer initially, and they wait 4.5 years, which is beyond any
You haven't indicated what
time.
the unfair advantage is. If you had all the discovery you needed, and you got everything you needed to know from the IG, then
claim.
What's the unfair advantage?
The claim is gone. I can't file, if, this is the kind of thing you bring up in a pre-answer motion to dismiss or you plead it.
That argument is that the prejudice is that they have a meritorious defense. And I don't think that's what we meant in the case law.
Thank you, counsel.
Thank you.